preeminent scholar of post-World War II war crime trials, particularly West German Holocaust trials. He received his BA at Carleton College here in Minnesota and his MA and PhD at the University of Chicago. Professor Pendas is the author of the Frankfurt Auschwitz Trial, 1963 to 65, Genocide, History, and the Limits of the Law, published by Cambridge University Press, as well as numerous articles including Law, Not Vengeance, Human Rights, the Rule of Law, and the Claims of Memory in German Holocaust Trials, which won the Ignacio Martin-Barrow Human Rights Essay Prize. And today he will speak to us about Holocaust representation in German post-war trials.
Well, I'm not going to answer Mark's question, but I am actually, we didn't plan it this way, but it's going to work out pretty well. I'm going to explain some of the answers that some people have given to that question, and talk about some of the consequences of different ways of answering those questions, right? So this is actually rather serendipitous, if unintended. I want to talk about the way that the Holocaust in particular was represented in two major Holocaust trials that took place in the 1960s, and then one major Holocaust trial that didn't take place in the 1960s, but might have done. Right? So I'm going to look at the Eichmann trial in Jerusalem. I'm going to look at the Frankfurt Auschwitz trial, which took place obviously in Frankfurt. And then I'm going to talk briefly at the end about the investigation that was ongoing in the 1960s of the Reich Security Main Office. That's the branch of the SS bureaucracy that was most directly involved with organizing and implementing the Holocaust. There was a major criminal investigation underway by the Berlin prosecutor's office in the 1960s that was short-circuited by a fairly technical change in the way the statute of limitations worked in German law, and had to be abandoned because of this change in the legal statute around that. And I'm going to talk a little bit about how each of these trials came to a sort of different legal understandings and therefore different kind of representations, different political understandings, as it were, of the Holocaust, of genocide more generally. Essentially what I'm going to say is that the Eichmann trial offered basically a political understanding, an ideological understanding of the Holocaust as having been driven by anti-Semitism, right? As having been the outgrowth of Nazi ideology. The Auschwitz trial, the Frankfurt Auschwitz trial, offered essentially a psychological understanding of the Holocaust as having been driven by the perversion, the perverse sadism of individual perpetrators, right? And then that the Reich Security Main Office investigation that didn't result in a trial, so it's speculative, right? But because that was a trial that would have been very centrally about a bureaucracy, right, would have had no choice but to offer a more impersonal, structural explanation of the Holocaust, of perpetration in the Holocaust. In other words, what we get from Arendt, right, in Eichmann in Jerusalem, is, I think, a misreading of what was going on in the Eichmann trial in the courtroom, right, but would have been a pretty accurate description of what would have had to have happened, right, in a Reich Security Main Office trial had there been such a thing, right? It's not about one of these approaches being better or worse than the others, but it's a question of kind of a combination of the way that the law worked in each case and prosecutorial strategy having different kind of representational implications, right? That's a lot to try and cram into 25 minutes, so I'm going to be mighty sort of quick about all of this, right? Basically, this is a story of three different universalisms, right? All of which can be an element in the formation of what Nathan has wisely called, I think, cosmopolitan memory, right? That a specific event, in this case the Holocaust, can become an element in the collective memory of a whole bunch of unrelated people, right? Why do we have a Holocaust museum in the United States on the National Mall, but we don't have a slavery museum yet, right? I mean, it's an interesting kind of phenomenon, and these kinds of universalisms are part of that. There's the legalist universalism of the Eichmann trial, which takes this political story and turns it into a legalist idiom and universalizes it that way. There's the psychological universalism of the Auschwitz trial, which basically says there's sick, mentally ill deranged people in all societies, and they will do really bad things if circumstances allow. And then there's the kind of the bureaucratic, impersonal structures of modernity universalism that would have been a characteristic of the Rice Security Main Office trial that becomes only a scholarly trope. It never becomes a legal trope because that case doesn't happen, right? Okay, so the Eichmann trial was prosecuted under a complicated kind of legal situation, right? There was essentially the so-called Nazi and Nazi collaborators punishment law, right, which was sort of an odd law, right? And its earliest precursors lie in efforts to prosecute Jewish collaborators with the Nazis, capos, mainly from the camps. In the DP camps already right after the war, 45, 46, you get trials in the DP camps of Jewish capos. These are sort of precursors to what's going to become the Nazi and Nazi collaborators punishment law, right? And it was part of a project of kind of reconstituting the Jewish community by punishing those within it who had violated the bonds of solidarity, right? Now, this then begins to be debated in the Knesset already in 1949, and the Israeli government presents a bill in March of 1950. And the debate about this bill is really stormy, and the main issue was how Jewish should the law be, right? And this in two respects. Should it deal only with Jewish perpetrators, right? So it should really only be about Jewish collaborators who are to be punished, right? And secondly, should it punish only crimes against Jewish victims, or should it also cover crimes committed against non-Jews, right? The initial government draft of this law made no specific mention of Jews, but it was clear from the start that the real target of the law was not Nazis, and certainly, not German Nazis, but rather Jewish collaborators. Part of this was pragmatic. They didn't really expect, Adolf Eichmann to come to Tel Aviv for a vacation. But part of it was political, right? That the stakes for Israel were not primarily about what to do about Germans, but what to do about breaches within their own community, right? So when Pendas Rosen, the Israeli justice minister, introduced the bill to the Knesset, he said, quote, "Finally, another word about the practical implications of this law. The law applies also to those who carried out the orders of the Nazis, and we cannot, unfortunately, be sure that such people are not among us, although they are certainly few in number. The proposed law may furthermore contribute to the clearing of the air among the surviving remnant that has emigrated to Israel. Everyone who is familiar with its problems knows how painful is the issue of suspicion and mutual accusation that to this day hover over some of those liberated from the camps and ghettos who have immigrated to this country. Let our camp be pure," he said, right? So this is really about forging conditions for internal solidarity within Israel, and particularly within the Holocaust survivor community within Israel, right? This is a kind of called a practical implication, right? Because the goal is to consolidate unity within Israel and to eliminate sort of fundamental divides within Israeli society, right? The significance of this comes out with the trial of Rezno Kastner, right? Kastner was an associate of David Ben-Gurion, and he had been involved in the Trucks for Blood deal with Eichmann to try and rescue some Jews, right? He was prosecuted in 1952 under this law as a collaborator with the Nazis. It was in the context of that Eichmann's name became a kind of a household word. I mean, before that, Eichmann was a relatively obscure figure that people didn't know about. The Kastner trial is something of a fiasco. It ends in an assassination and actually heightens the divisions within Israel rather than bringing about greater solidarity. But this idea of emphasis on punishing Jewish collaborators was practical in a second sense as well, right? In the first decades after the war, the Israeli government was making no systematic effort to hunt Nazi Holocaust perpetrators. There were some private individuals who were engaged in Nazi hunting, but the government wasn't, right? Whether Eichmann or anyone else. And indeed, it was a German, right? The Hessian Attorney General Fritz Bauer, who's responsible for the Auschwitz trial, who's the one who was instrumental in finding Eichmann in South America, not the Israelis, and he has to actually persuade the Israelis to get him because He doesn't trust the Germans. He's not going to put an extradition request in. He figures Eichmann will disappear if he does this. So he convinces the Israelis to go after Eichmann. So in this context, right, the Nazi and Nazi collaborators punishment law ended up covering not just crimes against Jews and not just crimes by Jews, right? It ends up being more universal in its content, even if the political purpose was always very specifically Jewish, very specifically concerned about the Israeli community. It includes war crimes and crimes against humanity, and it enables the prosecution of non-Jews as well as Jews, which is fortunate when they get their hands on Eichmann, right? But it also includes a provision, and this is really important, for crimes against the Jewish people, right? So it's not just crimes against humanity or war crimes cast in this universal idiom, but crimes against the Jewish people. And 4 of the 15 counts in the Eichmann indictment are for crimes against the Jewish people, 7 are for crimes against humanity, 1 for war crimes, and 3 for membership in a hostile organization, right? So crimes against the Jewish people are a major element, but they're not the only element in the Eichmann indictment, right? Yet I would argue that this element in the indictment tends to loom larger than the others in the actual trial, right? That the crimes against the Jewish people, for perfectly justifiable reasons, tend to loom much larger than Eichmann's crimes against non-Jewish people, right? As the great political theorist Judith Sklar put it in 1964, the Eichmann case does not really create new problems for legal theory. Eichmann, alas, was always a Jewish problem. Once he landed in Jerusalem, his trial became an issue of Jewish politics and interests, both in Israel and in other Jewish communities. I think that was what people like Gideon Hausner wanted the Eichmann trial to be, and I'm going to talk about the ways in which it became something rather different than that in the course of the trial. Again, I moved to a kind of a legalist universalism. Hausner, who was the Israeli Attorney General, served as lead prosecutor in the Eichmann case, clearly wanted this to be a trial about the Holocaust in this narrowest sense, right, of crimes against Jews and only Jews, and to see it in a very Zionist idiom as the outgrowth of centuries-long history of anti-Semitism, right? That Eichmann was simply the end of a long line of perpetrators of pogroms and atrocities against Jews, right? And Hausner famously declared in his opening statement, "When I stand before you here, judges of Israel, to lead the prosecution of Adolf Eichmann, I am not standing alone. With me are 6 million accusers. I will unfold this awesome indictment." Right? He went on to say, "The history of the Jewish people is steeped in suffering and tears. In my blood lives," says Ezekiel. This is the imperative that has confronted our nation ever since it made its first appearance on the stage of history. So there's biblical roots, right? I mean, he really chases the origins of the Holocaust back to the Bible, right? And that's a very powerful political, perhaps theological message in the context of a new state of Israel that is, not quite 20 years old at this point, right? And so for somebody like Hausner, the Eichmann trial was at its core not just about the recollection of Jewish catastrophe, but also about the imperative of Jewish survival, and that of course meant Israel for him, right? And about the consolidation and strengthening of the state of Israel. And this is a deeply Zionist narrative, where we're talking about the other alternatives to Zionism that existed in the interwar, and Hausner is trying to use the Eichmann trial in a sense to say there is no alternative but Zionism, right? The diaspora in particular is not viable, right? I mean, there's an implicit critique of diaspora Jewry in Hausner's framing of the Eichmann case. It's also in a way implicit in the Nazi and Nazi collaborators' punishment law and this emphasis on making our own house pure, right? You see this in the kind of testimony that Hausner called at the trial that had nothing to do with Eichmann, that drove a rank nuts, right? When she observes it, he brings all these people in to testify about generalities about the Holocaust and stuff that are completely irrelevant to the question of Eichmann's personal guilt. For instance, Rahel Auerbach from Yad Vashem, who had been involved with Ringelblum in the creation of the archive of the Warsaw Ghetto, so this very involved person, doesn't know a thing about Eichmann, never met him, right, is called to testify, and she's asked to give a, quote, Hauser asked her for a general description, a very concise one, of Warsaw as it was from a Jewish point of view before the outbreak of the war. Now, how that's relevant to Eichmann's guilt is anybody's guess, right? But it's politically very important for the story Hauser is trying to elicit, right? She says, I would want to speak mainly about Warsaw from the spiritual aspect, about the cultural world of Jewish Warsaw. When I came to Warsaw for the first time, I was astonished at the intensity of Jewish life. It was especially the Orthodox Jews who made an impression on me. This Jewry, Orthodox Jewry, was the great reservoir of Jewish life. Jews from modern social strata, the intellectual elite, all the time were leaving Jewish life, but these Orthodox Jews remain, and they continually produced new strata of cultural creation. There was a complete Jewish state there, she concludes that comment with, right? Again, I mean, as a kind of a Zionist interpretation of this groupism of interwar Jewry, there was no Jewish state in Warsaw in the interwar period, but to frame this group identity, which there definitely was, in state-like terms, is to reinterpret this in a different idiom, right, in a more Zionist idiom. Okay, so this is what Hauser is trying to do. This is the prosecution's case in the Eichmann trial, right? You know, somebody like Arendt hates this aspect of the trial with a passion, right? But what's relevant for us, right, is that this project fails. Right? That this project of turning this into a purely Israeli Zionist narrative fails, and it fails in part because the judges in the Eichmann trial have no patience for this. Right? They fairly quickly in the proceedings start reining in Hauser from his digressions. They start policing the witnesses much more closely than they do at the start. And above all, right, what happens is that in the end, their judgment tells a very different version of this story from the one that Hauser offers, right? Their judgment is a story that has, you know, almost nothing to do with Zionism, right? It is a universal story of legal responsibility for individual actions, right? So they take the collective dimensions of Eichmann's actions out of the story. They emphasize his volitional choice, right? They emphasize his personal responsibility, and I think that this inversion really of the Zionist narrative into a much more universalist language of legalism, which is so characteristic of the judgment in the Eichmann case, then creates the conditions in which Eichmann can become a universal symbol, not of Jewish suffering, but of human evil. Right, the way in which the Holocaust gets mobilized in all kinds of contexts to stand in for any kind of suffering. Right, anytime anything bad happens in the world, somebody's going to stand up and say, "It's just like the Holocaust." Right? Well, part of that happens because of the way that the court turns Hauser's Zionist narrative on its head and universalizes it and allows that to function as a metaphor for kind of universal evil. All right, so that's a quick version of the story of the Eichmann trial. Now, the Auschwitz trial does something very, very different, right? And here I can just, one quick case, right? So, a guy named Wilhelm Boger, who is one of the 20 defendants in the Auschwitz trial. At the end, he's convicted on 114 counts of murder and 2 counts of accessory to murder for his crimes in Auschwitz. As mandated by paragraph 211 of the German Criminal Code, Boger receives 114 life sentences for the counts of murder. On the counts of accessory, he received a combined sentence of 5 years in prison for the 2 counts of accessory. Fine, this seems pretty reasonable, right? Accessories are typically punished less severely than perpetrators, right? You got a mandatory life sentence for being a perpetrator of murder, so 114 cases, right? But Boger's weird in the sense that he's the star defendant in the Auschwitz trial. He was known as the devil of Auschwitz. He invented a particularly gruesome torture device called the Boger swing, right? He is almost straight out of central casting for an evil Nazi, right? I mean, he's a walking cliche, right? I mean, he's a complete thug, complete racist, complete sadist, right? But his sentences, right, in all 114 life sentences that he gets for murder, were cases where he was convicted, where he had directly killed the victims with his own hands, often literally with barehanded, right, by beating them to death, but in some cases shooting them in kind of extrajudicial executions, right? The two convictions as an accomplice directly concerned the actual extermination process in Auschwitz, right? In both cases, he was convicted of participating in so-called selections, right? You've seen the photos, right? The people show up at the camp. They're divided into two groups. One gets shipped off to the gas chambers and killed. Immediately, another is admitted to the camp to be slowly worked to death, right? In those two cases where he was involved in the selections, right, the total number of victims was 1,010 people, almost exactly 10 times as many victims as in the 114 cases of murder, right? In other words, right, so for torture, Boger gets 114 life sentences. For genocide, he gets 5 years, is what it basically comes down to, right? There is something mildly perverse about this, right? I mean, this is a very odd kind of way of approaching these issues. The reasons for this are fairly complicated. I'm going to give a very quick version of this, right? German criminal law basically distinguishes murder from manslaughter on the basis of specific motives. You have to have a very specific set of motives, so it's not about intent, right? You can intentionally kill somebody and not have it be murder, right? It's about a very specific set of motives, the most capacious one being base motives, right? More relevantly here is the way they distinguish perpetrators and accomplices, right? So a perpetrator of murder is somebody who has these base motives for the killing are his own, right? They either, so the class case is, I am a mean guy, I kidnap people and I murder them for fun, right? Well, that would be a classic case of somebody being a perpetrator, right? I internalize these motives, they're all mine, right? In collective actions, right, then it's a question of have you internalized the base motives that led to the crime, right? If you're participating in the crime for reasons other than those sort of originating base motives, you're an accomplice. You're not a perpetrator, no matter what your actual contribution to the crime is. So the kind of the classic extreme version of this is a so-called bathroom case, right, in German law, where a woman drowns her sister's baby, right? So woman X drowns her sister Y's baby in the bathtub, right? Seems pretty straightforward, right? Woman X killed the baby. She should be a perpetrator. She's not, right? Because the base motives that led to the death of the baby were the sisters, the mom, right? Y didn't want the baby. She felt overwhelmed. She couldn't handle the baby. So her sister, acting on her behalf, drowns the baby. The criminal motives stem from Y, not from X. So X, who actually kills the baby, is an accomplice, while Y, who didn't harm the baby at all, is the perpetrator, right? This kind of notion of you have to internalize the originating base motives is really crucial then, because in Holocaust cases, like the Auschwitz trial, right, what it does is it in effect rehabilitates the so-called defense of superior orders through the back door, right? After World War II, almost all legal systems say basically you can't just saying you're just following orders isn't a legitimate defense for participating in mass atrocities, right? This is explicit at Nuremberg. German criminal law incorporates a lot of this, right? So you can't just say, I'm innocent because I was following orders. But what you can say under German law is, not I'm innocent because I was following orders, but I'm only an accomplice because I was following orders. I didn't internalize the base motives, right? The base motives, German law holds, basically stem from Hitler, Himmler, and Heydrich, right? There are three main perpetrators of the Holocaust. They're the ones who had the originating base motives. Everybody else is either a co-perpetrator, if they internalized those motives, made them their own, as the law puts it, right? If they didn't, then they're only an accessory, an accomplice, right? So no matter how directly implicated you are in the murder of however many people, if you can plausibly say, well, I didn't have personal motives for killings. I'm not personally a vicious anti-Semite. I'm not personally a crazy sadist. I was just following orders. Well, then you're an accessory, and you're going to get 5 years for murdering 1,000 people, right? The way you demonstrate that people have internalized these base motives, made them their own, and therefore are acting as a perpetrator, you've got, unless you happen to come across their diary, as Dear Diary, I really hate Jews, I think I'm going to go kill a bunch of them today, right? You've got no evidence you can use for this. You look to the objective features of their action to judge what their motives must have been, right? So how are you going to know that somebody was acting with a perpetrator's will? Well, if they're sadistic, crazy people, right? If they're torturing people, if they're laughing maniacally, that's a pretty good sign they've got a perpetrator's will, right? But if they're a dutiful, quiet, law-abiding bureaucrat, well, there's no indication that they had a perpetrator's will then, right? So you're going to treat them as an accomplice. They're going to get a much lesser sentence, right? So this too, I would say, creates a kind of universalism, right? But an exculpatory universalism, right? If the universalism of the Eichmann court allows non-Jews to kind of lay claim to the subject position of Jewish victims of the Holocaust and say, oh, we're all victims of Eichmann, right? What this universalism of the Auschwitz trial does is it allows most Germans off the hook, right? Because it basically says the cause of the Holocaust was the perverse base motives of Hitler, Himmler, and Heydrich, or the nutty sadism of the direct on-the-ground killers like Boger, right? Every society's got its sadists, its serial killers, right? I mean, Germans are no different than anybody else in that regard. There's nothing particularly German, and there's nothing particularly political about this story, right? This is a story about psychological perversion, about sadism, which every society has, right? And circumstances in World War II kind of unleashed the opportunity for this, but there's no political story here, right? And so if you're not a crazy psychopath and you're German, you're off the hook. You're fine, right? And so it's a universalism, but a kind of a narrowing universalism that says really the world's evils are because of sort of mentally deranged psychopaths, and that's about it, right? So that's another kind of psychological universalism that basically said most people are okay, a handful of people are not, and we'll deal with them, right? Now, the last thing I want to just very quickly touch on is this investigation of the Reich Security Main Office that did not result in a trial, right? Essentially, they changed the sentencing guidelines for accomplices. Used to be they could receive up to a life sentence, but typically did not. In 1968, they changed this to mandate a maximum sentence of 15 years, which means that accomplices fall under the statute of limitations at that point. Prosecutors felt, and given this kind of way that German law distinguishes perpetrators and accomplices, quite rightly felt that they would never get these guys behind a desk in Berlin as perpetrators, because there's going to be no proof that they have this perpetrator's will, right? So they're only going to be able to prosecute them as accomplices. That's now under the statute of limitations, so they basically have to drop the investigation, right? There's a lot of question about whether this was actually done on purpose for political reasons, specifically to short-circuit this investigation. A lot of those files are still closed in the archives, so I don't think we know yet. I'm not sure we'll ever know. I mean, it's not the sort of thing you're going to write down if you're a politician. You say, I'm going to pass this little backdoor amnesty for important Nazi perpetrators. It's probably not something you're going to put in writing. But so whether it was done on purpose or whether it was somebody said, oh, we didn't realize that was going to be the result, who knows, right? We'll probably never be able to prove that one way or another, but it's certainly the result, right? This is a case that would have had to deal with, in a really direct way, two issues that were papered over in the Auschwitz trial, and were in a way not central to the Eichmann trial either, although they probably could have been. One is the role of the state. Right, the state bureaucracy, not just because the Reich Security Main Office was a party bureaucracy, not a state bureaucracy, but almost everything they did went through state channels, right? And so it would have brought into focus the question of the relationship between party and state in the Third Reich in a way that these other trials didn't. In fact, the Auschwitz trial very specifically excluded the role of the state. It focused only on the SS, right? The historical background testimony they had in the Auschwitz trial was only about the SS. The published version of this was called Anatomy of the SS State, which of course is completely misleading because the SS state wasn't a state. There was a state that helped the SS. The SS was a party, not a state apparatus, right? So it was really almost designed to hide the role of the state. right? This would have had to come out in the RSHA case had it come to trial, right? And it would also have implicated the ways in which you could be non-sadistic, non-psychopathic, and be centrally involved in genocide. Right? That, again, the kinds of things that Arendt is very interested in with respect to Eichmann, wrongly in that case, right, but would have been apt for a lot of these guys in the RSHA. And so we could have seen the ways in which bureaucratic organizations disrupt questions of individual responsibility based on personal motive, had this case gone to trial. Now, I want to end by just saying what's interesting is, Arendt does this in her reading of the Eichmann trial. She's completely wrong about Eichmann, right? Eichmann was, in fact, an ideologue, a committed anti-Semite, and that's clear now from evidence that's become available subsequently. But I think that she was right, not about Eichmann, but about the general question, right, of how do modern societies disrupt the causal connection between personal motives and collective action, right? It would have been nice for her to have been able to talk about a case where the evidence actually showed that, as opposed to a case where she had to basically misread the evidence to reach that conclusion, which I think is what she did in the Eichmann case, right? What's interesting is that sort of perception of bureaucratically organized, not personally motivated evil, right, comes out in scholarship. It comes out in Arendt. It comes out in the so-called structuralist interpretation of the Holocaust that emerges right about the time the RSHA case would have gone to trial, starting in the late 60s. Right? All of this stuff exists in scholarship. Right? Somebody asked earlier about, well, all this stuff about philosophers and stuff, but how does that actually meet on the ground? Well, one of the things that's interesting about the fact that this stuff all came out in scholarship and never made its way into a trial, and here we can pick up on some of Mark's points about the kind of the public function of trials, is that people in the know knew this stuff. Right, but it never made its way into the newspaper in quite the same kind of way. And it certainly never had the legitimating authority of a state trial behind it to articulate this vision. Right, so that this kind of vision of responsibility always remained kind of a purview of a relatively smaller segment of the public than it would have done had it reached trial. And just speculatively, can't prove it, but if you think about the way that the Germans in the 70s and 80s every few years had a collective freak out about the fact that the Holocaust happened in Germany. And they'd see the TV miniseries Holocaust in 1977 and go, oh my God, we had no idea. And then they would see Schindler's List in the early 90s and go, oh my God, we had no idea. And then they'd read Daniel Goldhagen and they go, oh my God, we had no idea, right? They're perpetually, sort of rediscovering their own past and kind of, having a crisis about it. And at least some of that's because this broader sense of culpability, this broader implication of state and society was systematically kind of effaced in the trials that did happen, might have emerged in the trial that didn't happen, and so that they could, learn a representation, see representation, learn a lesson about the past that basically left them unimplicated, so that when anything came along culturally that did implicate them, it was genuinely kind of shocking. I'll leave it at that. Your comment about sort of questions of mediation and audience, right? One of the things that is interesting to me is there are a lot of representations of genocide that are out there, right? And so what is specific about legal representations in a public sphere, right? Why do trials matter in a world with books and movies and Angelina Jolie, right? This is something I was actually, when I was first, not to make you feel old, Mark, when I was first working on this stuff, I was very influenced by your book and this notion that law tells a certain kind of story that has a certain kind of authoritative quality. Now, this is not to say that audiences can't reject legal narratives. I mean, if you think about, say, the Rodney King, O.J. Simpson set of trials in LA, right? And African Americans rejected Rodney King's trial story, and white Americans rejected the O.J. Simpson trial story. So audiences can reject trial stories, certainly, and that's an interesting phenomenon for scholarly analysis in and of itself. But trials have a certain kind, literally a certain kind of authority behind them. They have the authority of the state behind the stories that they tell, and also they have a kind of a forensic authority. People are trained to believe that trials are particularly good ways of eliciting truth, and so that the truths which trials enunciate have a kind of a prima facie believability that I can set up a web page in www.darfurgenocide.com, and the validity or non-validity of that would be highly disputable in a way that an ICC indictment has a prima facie plausibility to it because of this kind of sense that this is what trials do, they elicit truth, right? And so then when these legal stories are conveyed to a broader public through media, right, and the relevant media changes over time, right? When I was working on the 60s, I focused mostly on newspapers. Today, obviously, you want to look at web pages, but whatever it is, right? This legal story is itself changed, right? I mean, newspapers have their own agendas, web pages have their own agendas, they have their own field of professional norms, right, that filter and affect the way the legal story is perceived. Most people don't hear the legal story in an unmediated way. How many people ever sit down and read a verdict? People like us study these things for a living, but other than that, nobody, right? Nobody in the general public is ever going to actually read the damn verdict in a case, right? They're going to read newspaper accounts of it or hear TV stories or right? And so they're getting the legal story, once removed, filtered through norms and professional values of journalists or filmmakers or whoever it may be, right? And so I think that to really get at the full story of the effects of representation, of legal representation, you have to get at that kind of mediating step as well, right? So what's the legal story? What's the mediated story? And then what's the reception? So it's a three-part story that you have to tell. My talk was a little long today already, so I only told one part of that story, but I think it absolutely is imperative to tell actually all three parts. How do you deal with a group not one person? I think you're absolutely right. That's the problem here, right? Is that most legal categories are crafted for, even if they're groups, they're groups of, 3 people get together to rob a bank. That's a very different animal than hundreds or thousands of people get together in a political context to commit a political crime. And so it's the collective nature, it's also the political nature of these crimes that I think makes them particularly challenging for legal categories, all the more so when those legal categories, as in the Journey case, are mundane, ordinary criminal law categories rather than things crafted specifically with these kinds of cases in mind. So I thought it was absolutely right.